One of the most interesting things about the hearings that I found was Senator Specter's desire to talk about federalism and the power of Congress. And I'm curious your thoughts about Judge Roberts, soon to be Justice Roberts, what he might do in terms of striking down laws where the court, it seems to be in the direction of saying Congress has limited powers. My concern is the national driver's license, which is subsume the state police powers to license people, and it will essentially create a national ID, which is something that Roberts actually endorsed in terms of immigration. But I think a lot of people are concerned about the Civil Rights Acts, whether this would be a return to the Reconstruction period when the court struck down Civil Rights Act saying that really the Congress doesn't have that power. How would you read his feelings on federalism and Congress's power on those two separate issues?
Well, first of all, I don't think that any view of Congress's affirmative authority is so cramped and narrow that there would be a serious question about Congress's affirmative power to have a national driver's license, given that what it's doing is licensing a form of transportation that is inherently capable of and likely to move interstate. I think even Thomas, who has the smallest vision of national power, is likely to say, well, Congress has that authority. The question there would only be whether the impact on personal identity, on personal privacy, even when it's not abused, is sufficiently pernicious in the potential that it violates some limit on Congress. And I think that there would not be a majority in the current court, probably not even in the most liberal court we've had on these matters, the Warren Court, to strike it down on that ground. I think it would die if it did, and it probably will, unless the war on terror is used as an excuse for that as well, and it might be a justification, die in Congress rather than in the courts. Now, to get to the broader question, it seems to me that it's important to distinguish Congress's power under the Commerce Clause, its power under Section 5 of the 14th Amendment, the two main sources of power, one to enforce the Civil War amendments as limits on the states, the latter, and the former, its power to regulate commerce. Power to regulate commerce only in the hands of Justice Thomas and possibly Justice Scalia, if there were enough reinforcements, would return to what it looked like prior to 1937, which was a very categorical, conceptualized scheme that said that it is only interstate commerce that can be regulated, not economic transactions that are intrastate, regardless of how much interstate impact they may have. That's a view that Rehnquist didn't take. It's a view that Scalia doesn't take. It's a view that I would think it inconceivable that Roberts would take, even if as an original matter he might have taken it, and even if you can't tell just how much weight he would give precedent in general. I think that the destabilizing effect of that narrow reading of the commerce power is pretty much out of the question. Most of what Congress might want to accomplish can be accomplished simply by saying it has the power to regulate all economic transactions. Not everything. If Congress wants, for example, to create a federal cause of action for the victims of gender-based violence, it doesn't get there by the power to regulate economic transactions whose effect can be accumulated. So that no matter what Congress's findings, and however plausible they are, about the adverse impact on the national economy of violence against women who are less likely to enter the workforce because they might be victimized either there or domestically. The Rehnquist court set its face essentially against that, saying, it doesn't matter what findings you could make those findings about anything. If violence against women is thought to have the kind of impact on interstate commerce, not, however, being commercial itself, that justifies use of the commerce power, then so does everything. So does the time you put your children to bed. So does the kind of cereal you feed them. So does anything you can name in the aggregate has an impact on interstate commerce. All crime, all violence surely has a massive impact in the aggregate on interstate commerce. And what the court has basically said is we will not admit as a form of argument in favor of a congressional source of power anything that would leave the court without any principled way of drawing the line on our part, leave the court with limitless authority in a government that was designed to give the national government limited authority. Now, there may be things on the cusp. That the best example is the little toad. That is, how do you assess whether Congress is regulating an economic activity? The toad that's sitting there peacefully in California isn't an economic activity. The building project that destroyed the toad was. And the open question is whether the best way to justify such a law that regulates anything that might destroy the toad, regardless of whether the toad moves across the state line, whether the best way to justify it is to focus on, as the D.C. Circuit did, the economic character of some of the activities that hurt the toad, and it bothered Roberts that was the way the D.C. Circuit chose, or to make a claim and try to prove it that in the aggregate this species has an interstate effect. And Roberts was saying that might be a better way to go. And when the environmental movement got all exercised about him for raising that question, I think it was basically losing its sense of proportion. Now, under Section 5 of the 14th Amendment, and I better make this quick, under Section 5 of the 14th Amendment, which Congress doesn't have to invoke to do the Civil Rights Acts. That is, it can do the Civil Rights Acts as it did in the 1960s, saying any motel that serves food in interstate commerce or that serves travelers in interstate commerce has to pay a minimum wage, can't discriminate on grounds of sex. It has an adequate hook. But when it needs the 14th Amendment is when it wants to create the ability on the part of people who are the victims of state discrimination, state employees who are discriminated against based on age or disability, when it wants to let them sue, then for complicated reasons related to a completely atextual and indefensible reading of the 11th Amendment, it's got to use the 14th Amendment. And the court has tried to limit Congress's power under the 14th Amendment through a geometry created by the court, saying that the exercise of Congress's power has to be congruent with and proportional to the problem. And Scalia, who initially joined that, got off the boat in a case called Tennessee v. Lane, which involved a woman crawling up the stairs, a paraplegic who had to crawl up the stairs to get to a courthouse, and who was saved only by the ability under the Americans with Disability Act to sue unless they created an elevator or some other way she could get up. In that case, Scalia dissented from the court's decision that the Americans with Disability Act could come to the aid of the woman in the courthouse because access to court is a fundamental right, even though the disabled are not what the court calls a suspect and insular minority, could come to her aid. And Scalia says, no, that's not an enforcement of the 14th Amendment. It may be congruent as proportional as all hell. But being congruent and proportional is a judge-made, meaningless thing that I was brainwashed into joining in the earlier cases, and I get off that boat. And what Roberts pointed out in his hearings is, if something strikes Scalia as enough basis to change his mind in just 3 years, it must be pretty difficult, pretty complicated, pretty evolving. I'm not sure what I think. And I take him at his word. He's not sure what he thinks. And I'm not sure what I think he will think.
Thank you. Let's thank Professor Tribe again.
You're welcome. Thank you. Thanks for coming.